I know there's, some athletes who will sign multi-year deals. I know a few in particular. I'm a former track athlete, professional, ran on a professional level, ran collegiately, all the things. And I know there's some deals out there, and more so being put in front of, especially those coming out of high school, signing these multi-year deals, and it'd be a multi-year deal, $10 million deal, right? $15 million deal, 8, 6, whatever it is. It sounds great. Multi-year deal and you put million behind it. What, the money's a distractor. What do you think that athlete and their family hears? Millions, multi-years. But you have to look at all the other provisions that may affect that multi-year deal. Secondly, money depreciates. If you lock me in without speaking to inflation and everything else, I'm actually getting paid less on the 5th year than I got paid on the 1st year. And I have put in more work. More than likely, if all things given are great, I have improved. I'm not the person in the 5th year or the athlete in the 5th year that I was in the 1st year, but I'm getting paid less. So it's things like that to think about. And this is not just, we're talking about provisions and things that we need to think about, whether it's a deal with a label company, whether we're talking about leagues, whether we're talking about business to business, whether we're talking about employment. We need to understand what that transaction is and what are the things that we should be thinking about. And in some of the provisions, I'll point some out now. Intellectual property, that's huge, right? You need to go put the compensation provision down. We need to look at intellectual property. You knowing why you entered into this deal, is intellectual property an important component of it? What are the expectations of intellectual property ownership for one side of the contract and you as on the other side? And your intellectual property, for those who may be listening that do not know, I'm talking about trademarks, copyright. And if there's got something to do with invention with a business, then patent, right? So when you're creating some type of content, when you're providing some type of good or service, there is intellectual property involved, either as a copyright or as a trademark. And if you're someone who's contributing to producing content or providing products or services, then you're someone that's involved in curating intellectual property. So what does that look like? Is it just compensation for you and complete ownership to somebody else? Is it split ownership? Is it you retain rights? What is that? But you need to go to the intellectual property provision and read that to understand that. If you're being employed by somebody, by default, if you're employed for someone and you're creating something as an employee, that work belongs to the employer, not you, unless there's other conversations that are had. And you have to understand that depending on what you're being employed for, you have to understand what the default is. If you're not employed by someone, then it's possible that it can be work for hire for other reasons under the Copyright Act. With you providing a product or service may not still be yours, even if you're not employed by them. So go to the intellectual property provision and really understand that. Another provision that is highly overlooked is the jurisdiction provision. What state, what courts govern this agreement between us? If an issue arises, something happens, who actually governs how to deal with that issue? Is it even a court? Is it arbitration? Is it mediation? That means you're dealing with outside of the court. You're dealing with someone that's an arbitrator who will hear everything just like a court, hear everything, make a decision, and then you bind yourself to that decision, meaning you stick yourself to that decision. Or it could be a mediator who mediates you all figuring it out, and they're there to mediate the situation. But where is it happening? If it's an arbitrator, a mediator, a court, is it happening in the state in which you're in, the state which the other party's in? You may both be in the same state or different states. That makes a huge difference, because different states may have different laws, or may be favorable or less favorable to your issue, depending on where you're at. Some states may be more favorable to businesses, to employers, to labels, and less favorable to employees and someone who is providing something for a business or athletes. You have to see where and who governs enforcing this contract, and that is overlooked. And that can cause a nightmare. All that compensation you may have received may go towards actually fighting in a court for an issue that needs to be resolved. Another provision that needs to really be paid attention to that's overlooked is duration. How long is the contract for? You may have a term, right? A provision that says the term of this contract is this time to this time. Like, for instance, you may agree, I'm going to enter into a 5-year term deal. I'm going to enter into that, and that's my understanding. So when I sign this contract, I know it's a 5-year term deal. But as you go through the provisions, you may see different things in the provision that, or the provisions where certain things have to be delivered or done that may push back time. There may be a force majeure clause, means by the act of God, where something can be delayed and put on hold, or contract can be canceled. But it can stretch out the duration based on what other things are in the contract that has to be done. A 5-year, anticipated 5-year deal can turn into a 15-year relationship, especially when it comes to entertainment deals, depending on what is in the contract. So looking at duration, and duration is not, again, looking at just the term, look at other clauses that speak to the duration of what needs to be done, when it needs to be done. Another one is deliverables. It goes right to duration. What are the expected deliverables of this contract? What are either party is supposed to be bringing to the table? What service or product one party is supposed to bring? What is the other party supposed to bring? See what the deliverables are. But more importantly, in the provision that speaks to deliverables, you have to look at the standard of satisfaction of those deliverables. Especially a lot of times I get this in production deals, film deals. You have to understand, I have deliverables that I have to deliver, but am I delivering these deliverables at the satisfactory level contractually agreed upon? Otherwise, that can extend duration, or it can affect my compensation. Another thing overlooked is the transfers. The transfer clause and assignments clause. Can this contract be transferred? Which means, if I'm doing XYZ for ABC, can it be transferred over here? And now I'm doing it for whoever instead of who I thought I was doing it for. I'm going to give you a little nugget here. Again, it's not legal advice, and you need to get counsel. You want something, you come for a consultation, but because you are a seeker and you are here and you're listening and you're investing with your time, I'm going to give you this nugget. Like, if you're in a contract, if you're entering into a contract that's very important on who you're actually dealing with, then you have to look at making sure things are non-transferable, because there may be licensing that you want to give to someone as well. You want it to be non-transferable. But just giving your time in service, you want it non-transferable. It goes to the same as the assignment clause. If they can assign rights to someone other than who you expected for those rights to benefit, it can be assigned, while at the same time, those two clauses can speak to you not being able to transfer nor assign. You can't transfer the ability for your contract or you to provide a particular service, and you can't assign the rights and benefits you get to someone else. Which brings me to another clause. It's the last one I will talk about now, because these ones are very important. The parties. This is overlooked because, again, there's a conversation that obviously had to have been had, right? I get it. There's a conversation. So you think, okay, I know who this contract is between. I know the parties. But it has happened. I'm here to tell you, it has happened plenty of times. And it continues. It will happen. When you read that contract and you realize, but who's actual parties that's signing this contract and mentioned in this contract? You may be binding yourself to parties that you don't know that you're binding yourself to. And I know I said this would be a last one, but this is kind of connected to parties. So I'm gonna throw this one out here too. The signatures. That is completely overlooked. Look at the signatures, because who you think you may be entering into, are they even signing? Are they a signing party to this contract? And in what capacity are they signing? And what capacity are you signing in? Are they signing in the capacity of their representative capacity within that business, within that label, whatever it is, within that league? Are they signing within their representative capacity and you're signing within your individual capacity? Or are you signing within the capacity as a representative of some entity that you formed? So now it's entity to entity and not entity to individual. Signatures is very important. That is really, really important. Putting your name on the dotted lines. And by default, naturally, individuals sign contracts in their individual capacity. Even when you are a business owner and you're doing this deal as a business owner, plenty of times, individuals are signing the contract in their individual capacity, not in their representative capacity as a business owner. So when something happens and it goes back to jurisdiction, you don't know where or how you're going to resolve this something that happened. You're resolving it as an individual who may be affected, not as a business, as an individual who's protected by their business, if you do not sign the correct way. I see this a lot with the commercial leases that I review, especially with transfer assignments, right? That is one of the industry standard thing that a landlord is going to say. They're going to transfer. They have the right to transfer and assign all the rights of this contract, all of the obligations that you owe to them, to someone else that you do not know who that may be. You don't know who that may be, and you locked yourself into it. So it's important to really understand those particular provisions and what to do about them. So if you don't know your contract, you're already losing. If you don't know your contract, you are already losing.